Hello everyone. Today we are going to talk about a new topic in environmental studies and environmental law. Today's topic in environmental law is environmental law and law of crimes. We will talk about the relationship between IPC and criminal procedure code with environmental violations in our country. The list of topics to be covered here are the environmental law and law of crimes. We will talk about common law remedies and as well as criminal law remedies. Then we will talk about some relevant provisions of IPC and some remedies as provided under Code of Criminal Procedure. We will look upon some case studies also. Let's talk about environmental law and the law of crime. There is a relationship between law of crimes and environmental law. Certain environment violations has been declared as crime under IPC and criminal law. Environmental crime refers to the violations of laws intended to protect the environment and human health. These laws govern air and water quality and dictate the ways in which the disposal of waste and hazardous materials can legally take place. Individuals or corporations can be found guilty of environmental crimes. Let's talk about some common law remedies available for environmental violations. In India, disputes connected with the environment and traditionally subjected to the common law remedy. The factors governing the decision to take action against polluters are mainly personal. Common law remedies provide wide range of protection for civil rights in order to protect the person and property of individuals. Nevertheless, common law remedies incidentally provide for the protection of environment. Courts are also empowered to issue temporary and permanent injunctions under the Code of Civil Procedure and Specific Relief Act for controlling and abating pollution. Let's talk about some criminal law remedies. In addition to the common law remedies, Indian Penal Code imposes a criminal liability on polluter. Related to environmental protection, the provision has been defined in Chapter 4 of the IPC. Some of the provisions are Section 268, Section 290, and Section 277. Some relevant provisions of IPC. First of all, Section 268 of Indian Penal Code 1860. Under this section, public nuisance has been defined. In this, the following ingredient has to be fulfilled. A person is guilty of an offence if he does any act or an illegal omission. Such act or illegal omission must cause any common injury, danger, or annoyance to the public or to the people in general who dwell or occupy property in the vicinity, or obstruction, danger, or annoyance to persons who may have occasion to use any public right. Such act or illegal omission must necessarily cause injury. Now, Section 290 of the Indian Penal Code 1860 talks about it provides punishment for public nuisance, which includes pollution cases also, in cases not otherwise provided for. These offences are punishable with fine which may extend to 200 rupees. Let's look upon a case study in K. Ramakrishnan versus State of Kerala. The Kerala High Court held that smoking in any form in public place is a public nuisance, and cases can be filed under Section 290 of the Indian Penal Code as it is violative of right to life provided under Article 21 of the Constitution. Section 277 of the Indian Penal Code 1860 talks about as regards to water pollution. Section 277 requires there must be a voluntary corruption of fouling waters. The water must be of a public spring or reservoir. The water must be rendered less fit for the purpose of which it is ordinarily used. Fouling of water of river running in a continuous stream is not an offence under Section 277 of IPC, but yet it may be an offence under Section 290 if evidence shows that the act was such as to cause common injury or danger to the public. In Namarao, the accused and nine others were charged under Section 277 of the IPC with the offence of fouling water of the river and rendering it unfit for drinking purposes by steeping therein alloy plants with a view to extracting fibers therefrom. The lower court convicted them. On appeal, the High Court referred to its earlier decisions and held that a river is not a public spring as contemplated in Section 277. Yet, from the description given, it might be a nuisance under Section 290 of Indian Penal Code 1860. It is indeed very unfortunate that the courts failed in suppressing the mischief and advancing the remedy. A more beneficial construction ought to have been given for the term public spring and reservoirs so as to include waters in running streams, canals, and rivers. Let's talk about some remedies under Code of Criminal Procedure. There are certain remedies provided under Code of Criminal Procedure for environment protection. The provisions of Chapter 10 of the Criminal Procedure Code of 1973 provide effective, speedy, and preventive remedies for the public nuisance cases, including insanitary conditions, air, water, and noise pollution. It contains provisions for enforcement of various provisions of the substantive law. Section 133 of the Criminal Procedure Code provides that a district magistrate or subdivisional magistrate or any other executive magistrate can make a conditional order to remove nuisance, and if the nuisance maker objects to do so, the order will be made absolute. The remedy under Section 133 of Criminal Procedure Code has several advantages that should lead to its choice in seeking to prevent environmental damage. Any person can simply complain to an executive magistrate to set it in motion, keeping in mind the mandatory nature that has been read into Section 133. It is also comparatively speedier, and when evidence is taken under Section 138, it is to be taken as in someone's case, which provided for trial in the summary manner. Section 144 of the Criminal Procedure Code confers powers on an executive magistrate to deal with the emergent situations by imposing restrictions on the personal liberties of the individuals, whether in a specific locality or in a town itself, where the situation has the potential to cause danger to peace and tranquility in such an area due to certain disputes. In addition to Section 144 of Criminal Procedure Code provides for situations of emergency where orders can be passed ex parte. The magistrate has wide powers under Section 133 to stop or remove the nuisance. Even he can pass orders requiring public bodies to perform their mandate. As I conclude this, that the Indian judiciary has tried to interpret the provisions of various laws to provide speedy remedy for the problems related to environment. Apart from common law, Indian judiciary has provided remedies under criminal law and imposed penalties on environmental violations.